Welcome once again to Lehto's Law. Here's Steve Lehto.
We talk a lot about civil asset forfeiture on this channel. It's something that upsets a lot of people, and rightly so. People have a hard time understanding how the government can justify just taking money from people and saying, you want your money back, sue us. And so we've talked about how crazy that notion is, but it's also one of those things I think that it really gets people upset because they go, well, it also doesn't make any sense. It's unfair, but it also doesn't make sense. There's a distinction here, I know, but follow me on this one. Story from Reason.com. A whole bunch of people sent me this. Thank you very much. Billy Binion wrote it. There's a man in Indiana from whom the police seized almost $10,000. And the court ruled he was not entitled to any kind of help with representation because you got to hire your own attorney. Of course, he would have hired an attorney with the money that they seized from him, but he doesn't have it anymore. So it puts you in a weird situation because the government can keep you from getting representation by seizing your money, and you can't hire an attorney if you haven't got any money. And you also can't get help, like saying you're indigent, because they say that's not how that works. So it's a crazy story involving a guy named Terry Abbott. Terry Abbott. And this case went to the Indiana Supreme Court. Indiana, of course, is the same state where Tyson Timbs had to fight and go to the U.S. Supreme Court to get his vehicle back after it was seized over a minor offense. So in April of 2015, police in Indiana seized almost $10,000 from a man named Terry Abbott after he was arrested for selling drugs, they said, to a confidential informant. Now, this case went to the Indiana Court of Appeals as well as the Indiana Supreme Court. A couple of different opinions on this one as it went through the legal system. But at first, cops used the civil forfeiture procedure to take the $10,000 from the man, and that allowed them to proceed by taking the money from him. They did charge him with a crime, but I believe those charges were never followed through with. But it doesn't matter. Abbott attempted to challenge the action in court. He had an attorney at first, but then he ran out of money because the rest of his money was in the possession of the government. So when he went before the court and said, I no longer have an attorney, can you provide me counsel or let me use my money to hire counsel? Trial court said no. No, that's not how it works. Once we seize your money, it's not yours anymore. It's not technically ours either, but you don't have control of it anymore. But one of the reasons, and some people would catch this, is that if you appear before the court as a criminal defendant and you haven't got money, you can get an attorney appointed for you because you can't afford one because you're considered indigent, right, if you haven't got the money. Well, here, he's not before them with the civil asset forfeiture proceedings as a criminal defendant. He wants to prosecute the case to get his money back. But there are things in court, situations where you can ask for the courts to grant you some privileges because you haven't got money. For instance, to get a transcript from a hearing costs money. So if you attend a court one day, and let's suppose you go to court and you spend a day in court on some legal matter, and you decide to appeal that legal matter, you have to get a copy of the transcript of those proceedings. Transcripts can be very, very expensive. So they'll often say, well, we'll get you the transcript. You got to pay to have it transcribed. Well, if you haven't got the money, you can often go to the court and say, I'm going to ask for a waiver on the cost of transcription. I haven't got the money. Here's why. And the courts can waive those fees and say, well, this person here is indigent. They can't afford to pay for the transcription. And justice would require that they be allowed to make the appeal. So the man asked the trial court, could you make such an exception for me? Because I haven't got the money because they took it. Trial court said, no, that's not how this works, my friend. So he took that up to the Court of Appeals, and the Court of Appeals actually spun this around and said, no, obviously, if you take the money from the guy, you can't then penalize him because he's got no money. Unfortunately, the state of Indiana appealed that to the Supreme Court of Indiana, and the Indiana Supreme Court said, oh, no, it's perfectly reasonable to say this guy has to pay his own way even though the state took his money. So the Supreme Court reversed it and sent it back down and said that's absolutely fine. That this man, we took his money from him, and now we're going to punish him in essence for having no money. So he attempted to challenge the action in court, but he lost his attorney because he couldn't pay for the attorney. So for years he had to represent himself. Court of Appeals, Indiana Supreme Court, like I said, it wound its way through the legal system. And the Indiana Supreme Court recently decided that in keeping with the law, they ruled that defendants have no right to use their seized funds to finance legal representation. And they also ruled that on the issues that you might be able to get away with something because you're indigent also don't apply if your indigency is caused by the state seizing your money. That's where it gets really crazy, because if you think about this, if the state takes your money and wants to keep it, not only are they incentivized to keep the money because they get to keep it and spend it, but they keep the money to prevent you from representing yourself properly with an attorney, and the situation will not go as easily for you if you're representing yourself. We do not find the legislature intended this language to give the court equitable authority to order the seized property released to the defendant to defend the forfeiture action, wrote Justice Stephen David, noting that the court's hands were tied by the relevant statute on the books. Of course, the Court of Appeals in Indiana said their hands weren't tied, but the Supreme Court said, yeah, no, they are. They are. So Abbott didn't qualify. Central to the American criminal justice system is that every defendant is innocent until proven guilty. And civil forfeiture isn't a criminal action, however, and that's the problem. It's a civil one occurring in civil court where defendants are not necessarily entitled to a lawyer paid for by taxpayer expenses. Only in certain extraordinary circumstances, the court ruled, is the state required to provide one, and Abbott did not qualify. This means that in cases like his, the government is able to put defendants in a chokehold by seizing the very assets they'd used to defend themselves against such a seizure. Fighting to get your cash back is a bit difficult when the government has taken all of your cash. And the legal system ain't cheap. Just trust me on that one. An attorney for the Institute for Justice and a lawyer for Abbott in the later proceedings. One of the many pernicious things about civil forfeiture nationwide is that the government has the power to seize your cash and your cars and your home. But unlike in a criminal case, you don't have a right to appointed counsel. So if you want to defend your cash or your car or your home in a civil forfeiture action, you typically have to pay for a lawyer yourself, and that's not surprisingly economical or feasible for people who are targeted in civil forfeiture actions. So they took all your money. How are you going to hire an attorney? And some people are going to say, but Steve, we've raised this point before. We've talked about how difficult it is to defend yourself when you have to prove that your money is innocent in this convoluted situation. But here, this argument was made to a Supreme Court of a state where somebody pointed this out, how unfair this is. And the Supreme Court of the state said, well, the way their laws are written, we're kind of stuck with this. So too bad. Too bad. Because the Court of Appeals had ruled that the man actually deserved some relief as a matter of equity. And I've talked about this before. Equity is where a court does an action or tells someone to do an action. And so the Court on Appeal had said that the trial court should grant this guy his request for things like the waiver on the cost of the transcript and so on. And the Supreme Court said no. Courts cannot grant that kind of equity in a situation like this. And so this, I believe, is the first time this argument's been made at this high of a level. And that is somebody saying you are encouraging the state to take people's money, because money then goes to the police department, for instance, quite often. So they're incentivized to take the money. And they're also incentivized to take all your money. Because if they take all your money, you have a harder time pursuing the other money they took from you. So it's not an exaggeration to say that the state or the federal government can try to take you for nearly all you're worth in the process. People in Indiana know that quite well. The state was the setting for the Tyson Timbs case I told you about, where Tim's new Land Rover in 2013 was seized following his arrest, setting in motion an almost decade-long legal circus between Tim's and the government. That one went to the Indiana Supreme Court twice and the U.S. Supreme Court once. And he won at those levels. And the state refused to give up. They just kept beating a dead horse. And even after the U.S. Supreme Court ruled in Tyson Timbs' favor, they took it back up to the Indiana Supreme Court. So, well, there's still some issues here. And they get slapped down every single time. But they didn't care, because it's, when you're spending taxpayer dollars pursuing some insane goal, you don't care. But you're making the other person spend time and money. So prosecutors continue to fight that case, arguing before the Indiana Supreme Court that there should be no proportionality on what the government can seize in a case like Tim's. So in other words, if somebody does something wrong, they can seize anything in response to it in terms of the amount. And that was the issue. And the Tim's case at the U.S. Supreme Court level was argued more as a matter of an excessive fine, because the Constitution has said that fines cannot be excessive. But it was not argued as a straightforward civil asset forfeiture case. And some people have said that they shouldn't have done it that way. Well, at least they won. And the number one job of a litigant is to try to win their case. And so the case, they won the case. But so the state's highest court in Indiana rejected that argument finally last year. Civil forfeitures continue, however, and it's a source of police funding, with local and state departments able to keep the vast majority of the money they seize. Just last year, the Indiana Senate passed a bill to allow cops to seize assets from people suspected of committing unlawful assembly, a charge so vague that whether or not someone committed it is somewhat in the eye of the beholder, which of course would be the arresting officer. And I don't think I need to tell most of the audience this, that your right to assemble is something that is enshrined in the First Amendment. And so a lot of people remember the First Amendment, of course, is the freedom of the press. And they go, oh yeah, religion too. That's there also. And so is your freedom of assembly. You have the right to assemble. And it's the idea that people can get together. And quite often in the early days of our great nation, I'm sure you've heard stories of assemblies that were held in public squares where people might gather around to hear the words of Thomas Paine or Thomas Jefferson or some other Thomas of high repute, right? But the point is that your right of assembly is that important. And yet they passed a law saying that they can seize assets of people suspected of committing unlawful assembly. And remember, when they seize the assets of somebody, they don't have to get a conviction. They don't even have to have a prosecution. So they find somebody assembling, that is, two or more people gathering. They can arrest them, seize their assets, and then choose not to prosecute them for the unlawful assembly. But they've still got your stuff. And that was a recent bill passed. The Indiana Senate passed that bill recently. So I guess since the distinction here is the Indiana Senate passed the bill, it has not been made into law just yet, I don't think. But the point is that's the mindset of the politicians and law enforcement and so on, that we need to find more ways to open people up to seizure, to seize their stuff. And so if they're going to seize the assets of people suspected of committing unlawful assembly, they're moving it in the wrong direction, my friends. So if you're in Indiana, you might want to contact your legislators in the state and explain to them they're doing it wrong, okay? Civil forfeiture, of course, is also used at the federal level, and it presents many of the same problems. In May of 2020, the FBI seized almost $1 million from Carl Nelson after informing him he was under investigation for some kind of fraud. 2 years later, no criminal charges have been filed. The government returned some of the cash. However, the government's action made it a Herculean task for Nelson to push back, as he had been temporarily bankrupted. If you can't afford to defend yourself, let alone feed yourself, it becomes complicated, his wife told Billy Binion. As for Indiana, the ball is very much in the Indiana legislature's court, says Gedge, who is the attorney for the Institute for Justice. So it's a crazy case. And this, like I said, it's a common situation that somebody has their stuff seized and they go to court and they lose and they don't get to get their stuff back. But here, the guy specifically made the argument that I would be able to present this case better if either I got to use some of my seized money to hire an attorney, or if the court at least would forgive me for not having money because it was taken from me by the government. And the Indiana Supreme Court said, that's too bad, but we're not going to rule in your favor. Because there's a statute on the books, and the statutes on the books say that this is okay. We got no problem with this. Even though a court of appeals said, in the name of equity, we would have done this differently. And they actually did do it differently, but the Supreme Court of Indiana overturned them. So, article by Billy Binion, by a whole bunch of people. It's a fascinating case. Unfortunately, it came down the wrong way. We got a lot of work to do on this, my friends. From Reason.com, police seized almost $10,000 from him. A court ruled he had no right to an attorney, regardless. There you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I feel like I'm diagonally parked in a parallel universe.